So, good afternoon, everyone. In the series which we have started in under the broader brand of Best Interest Podcast, which is an initiative of independent thought, we continue to take up the very critical issue of age of consent, which is being debated both inside and outside the court with regard to should it get decreased or not? Should adolescent girls be allowed? um, in one way, people look at it as a right to certain thing, and then the other perspective which says that decreasing age of consent would actually empower or allow the men who wants to have sex with minor girls. So, and after decades of fight and decades of progressive legislations and court judgments, including the 2017 judgment of Independent Thought versus Union of India, the law today stands that any child below the age of 18 years is protected by the statutory provisions, and any person who engages with them with sexual intent or sexual activity can be prosecuted with severe offenses, including rape, and that can include husbands also. So, based on the same series, we have a very distinguished panel today. So, we have Dr. Himanshu Ranjan Nath. He is Assistant Professor of Law at the National Law University and Judicial Academy, Assam, Guwahati. And then we have Dr. Astha Dhingra. She's a clinical psychologist, works very actively with adolescents on suicide prevention and mental health program. And what makes her presence more important is that she has also served as a JGB member. So she has hands-on experience of engaging with the law and children. They have both have a very long illustrious brief, but I think when they speak you will realize how deeper their understandings are. So I'll just start with two things. I'll like to show a small 2 minutes video, which is our campaign video, and then we will start with the webinar.
The law on child marriage was first introduced in the year 1929, and it will be 100 years soon. However, nothing seems to have changed. Because girls are betrayed by her own parents, community, religious leaders, and others. While the Constitution of India guarantees equal rights and protection of law to girls, state has failed to protect girls from being forced into slavery in the name of early child marriage. Mission 2029 is an effort to change the situation where every girl is protected and is able to live a life of dignity on her own terms, for which the state must recognize child marriage as a violation of human rights, implement Beti Bachao Beti Padhao in the true sense by protecting girls from forced early child marriages, and by providing free, quality and compulsory education to girls till 18 years of age, implement laws and punish the violators. Every girl deserves a happy childhood, free from abuse, opportunities for education, free from illness, and most importantly, freedom to choose. You too can make a difference. Join the campaign against child marriage.
So, we all know, that the debate is on, and the law post POXO 2012 kind of criminalized sex with minor girls In fact, POXO is gender neutral. But 2017 judgment also removed the exception in the Indian Penal Code. The only exception which was there to the age of consent, which used to allow husbands to have sexual relationships. So, Himanshu, coming straight to you. So what I'll do is the pattern will be that I'll come with you to Himanshu, and then to Astha. I'll make three rounds, very quick rounds, and then we'll accordingly move. So Himanshu, as to the legal age of children and legal age of consent, very briefly, if you can just inform the audience the legal position today.
Listen, Vikram, am I audible?
Yes, you are.
Am I? So the thing is, main point here is, firstly, before going to age of consent, let me tell you very frankly that in India, the age of child is not determined, uniformly. We have laws, say the constitution provides the age of child. In one place, it is 6 to 14 for right to education purpose in Article 21A. And then if you move to Article 24, then it is 14. But the thing is, the universal, document on child, that is UNCRC, provides for the age of child is 18. And then in India, as you said, in POXO and the recently enacted BNS, it is 18, by the way. But there are laws, say, for example, the Trade Union laws, the Factories Act, the Young Persons Harmful Publication Act. Then we also have the Indian Contract Act, which provides for two ages. One is 18, one is 21 if guardian is appointed. So in India, first of all, the age of child is not uniform across the legal framework, number one. Number two, as you asked me to point it out about the age of consent, listen, age of consent historically in India, it got evolved from 10 years to now 18 years. The first IPC in India provided for 10 years as of consent in case of sexual relationship, and then it increased to 12, then 14, then we are right now having then 15 in the IPC, and then now it is 18. So there is disparity in uh, you know uh, the age of child, but as regards to consent, I would say that it is very timely approach by the Supreme Court on your organization's case, that it been realized that we have POXO of 2012, which prohibits sexual intercourse with girl below the age of 18 years. Consent is immaterial. Now, why the same provision should be there in the IPC? So it has been judicially wiped out, and when we got the new BNS 2020, that provision was not there, so it has come to 18 years. So basically what I have to say in this regard is that this age of 18 is, although legislatively, I mean, legally speaking, that 18 is the age of consent in India right now on law. But there are several judgments of the high courts, High Court of Karnataka, and then High Court of Madras, Delhi High Court judgment of 2024, and then there is Supreme Court in this month only provide a judgment where the Supreme Court also, asked for lowering the age of consent for the best interest of the child, which we will discuss at later point of time, by the way. So this is from my side, Vikram. Yeah.
No, thank you, Himanshu. That gives a very broader perspective as to how it has evolved, one. And second, the difference in age. Um, you're rightly saying that it's not fixed. And like 6 to 14 for some child labor also, the child gets defined as 14. And then there are very um, positive provisions. So if you look at the Juvenile Justice Act, while the child is defined as 18, but the provisions of aftercare even extend till 23 I think in case of Tamil Nadu till 25. So there are a lot of variations and how legislation see child vis-a-vis subject, and also child with a need. So that spacing, that the bandwidth is very broad. So thank you so much. I'm coming to Astha, to you. Uh, So just building on what Himanshu said, the mostly there is a range and all, but we now looking at the UNCRC and the kind of alignment we wish to see at the national level, and also the fact that JJ happens to be the kind of a mini constitution when it comes to children, because it not only looks at the substantial aspect, but it also looks at the procedural part of lot of issues. So I'm sorry, this is a new day hazard. So looking at, so JJ is very firmly on 16. I will also 18. I'll also touch upon the section 15 aspect also in the next question. uh, how do you look at, well, is 18 the right age? And I'm wanting you to tilt beyond the legal provisions. So is 18 the right age, from a purely psychologist point of view? Is 18 the right age, is, or should we, should can we think, should we think, your position, please?
So legally, yes, very rightly raised by Himanshu even. So legally, yes, but psychologically, if you see, it is protective, but I would say it is not perfectly precise. So in India, under POXO Act, JJB Act, Indian Majority Act, UN Convention, the rights of a child is defined as a person below 18 years. As someone who, me personally, who sat in juvenile justice board proceedings, I understand why 18 is kept as the cutoff. The law needs a very clear, uniform boundary. It cannot function on just an individual psychological assessment in every case. So, from my clinical experience and the developmental science, by 16 years, most adolescents can understand risks, consequences, pregnancies, STIs, social implications. Yes. However, the emotional control and the impulse regulation, it is still developing. This prefrontal cortex here, the control of the judgment and the self control area, this place still continues to mature into that early adulthood phase. And peer pressure, if it is strongly influenced, the strong peer pressure also influences the decision until the late adolescence. So 18, I think, is not a magical maturity point, but I think it is actually a safety boundary kind of a situation. I'll tell you what I've seen in practice while I was working with JJB. There was this 17-year-old boy who actually clearly understood what sexual intercourse is, how it is different from indulging and all other acts. So he understood that, but in a heated moment, under the peer encouragement कि ओ नहीं नहीं तू तो कर लेगा, अरे अरे तू इतना फट्टू है. So things like that, things like alcohol, things like emotional conflict, he acted impulsively in that heat of the moment. And later during inquiry, he is also himself shocked at the consequences. So the issue is rarely about the lack of knowledge here. I think it's about the lack of regulation. And we were talking about a lot of other countries. They have set the limitations as 14 to 16, talking about European countries. But when we are talking of those countries, we also need to closely understand few things. Most European countries set the age of consent between 14 to 16, but they also include strong sexual education. They also include close, what we call in age protections, and there are very strict laws for age gap relationships. If you actually see those things as well. So these countries somewhere separate the peer relations from all those exploitative adult relationships. So 18 is correct. I would say from protection standpoint, yes. From developmental standpoint, it is a broad safety shield, not an exact, I would say, a psychological marker yet.
Well, thank you so much. So many times the argument is that a lot of progressing, or say progressive, or already developed countries, especially the West, so we have this tendency of aping UK and US, European Union, for a lot of things, um, forgetting that the scenario, the culture, the family system are so different. And I was just making a quick, PPT. I was just searching, and then I realized, okay, let me put a 2 3 slide as an eye opener for everyone. That the and this is a little old data. The current data, I couldn't find the graph. The current data says that 40% of children born in the USA are to unwed mothers, and the number increases further if you go to the European countries. So, as high as 80% in Chile, 60% in France, uh, 52, I was looking at one data, 52% in UK. So, what we are saying is this is the number of say, percentage of children born, and they are born to unwed mothers, single mothers. And then there's also some data about USA where it is also linked to some community and educational background. So the question is, uh, Himanshu, I'm coming back to you. The whole idea of this evolving capacities and allowing, or say, opening up the protective cover, and not being protectionist, as some people say. Um, we should be working on the protection of children, but should not become protectionist. So this whole idea of evolving capacities, which are um, part of the UNCRC concepts, and also alongside the idea of best interest. How to balance? How do you see from the legal perspective? While we must respect evolving capacities in a lot of procedural aspect. So when say the JJB is engaging, we must involve them, and JJ Act beautifully has involved provisions for how child participation and their involvement must be ensured as part of both procedure and also within CCI, or even while developing individual care plans and etc. But for such issues of age of consent, how do you see evolving capacities taking over the idea of best interest? Himanshu.
Listen, first to Bikram, we have to take note of one very important thing, that when Justice Burma Commission has provided for the age, it has provided for 16 years. But our Parliament of India, the Parliament thought it prudent to increase it to 18. So the legislative intent in this regard is very clear in India, that 18 is the age. But if we look into the judgments, like several High Court judgments, there is one, it is State versus Hites of Delhi High Court of 2025 judgment, as you say, it clearly makes before us that the observation of court is something different. Now, judiciary is recognizing the view that there is a evolving process and there must be some relaxation as regards to the age, uh, because we have to cope up with the best interest of the child policy, like where the child's interest got secured. Like there is an example of Karnataka case where a 19-year, or a 21-year-old boy marries a 16-year-old girl, and they also have a baby. Now the Karnataka High Court has stated that the girl is secured with the boy. So if look, if public interest is not unveiled, public interest is not disturbed, then such kind of uh, evolving the age or relaxation of age, I would say rather, can be applied. Like we should apply. And people are often view the POXO Act particularly against the adolescent and teenage love. Why? Because it prohibits any kind of, or it actually exempts any kind of bodily autonomy for an adolescent, girl. So now that is not, in my opinion, that is contrary to our law. That is the Constitution, which Article 21 says everybody has a right to life and personal liberty. Now that right to life and personal liberty encapsulates within its ambit the right to choice, and the most importantly, right to dignity. Now that right to dignity and right to choice or right to autonomy, whatever you say, uh, in my opinion, is affected by this. Now here I would like to requote the Delhi High Court judgment in State versus Hites, where Delhi High Court said that societal and legal views on adolescent love should emphasize on right of young individuals to engage in romantic relationships that are free from exploitation and abuse. Love is a fundamental human experience, and adolescents have the right to form emotional, connections. So the law should evolve to acknowledge the respect and respect these relationships as long as they are consensual and free from coercion. So coercion and force, which is again provided as a ground in the countries you mentioned, like mostly European countries, even the USA also provides coercion and such kind of force as an exemption. Here also in India we can do so. Like there is a need to do it, and I support this evolution of I hope I'm clear in my point, Vikram. Over to you.
Yeah, you're clear. Just one clarification. The Justice Verma committee had pushed for 18 overall across. It
Yeah.
is the parliament which reduced it back to 16.
No. Burma committee provide for 16. It is the parliament which increase it to 18. Parliament increased it to 18. Burma
Okay.
commission was for 16. Yeah, it was for
No,
16.
when the ordinance came based on the Verma committee report, so the in the ordinance the age of consent was increased to 18, and for marriage it was increased to 16.
Hmm.
And which
Yeah,
when the
for
parliament,
marriage, I'm talking. Yeah.
हाँ हाँ okay, ठीक है. So coming back to you, Astha. So what Himanshu is saying, that he's looking from the prism of Article 21, and even young people have the right to choose and right to liberty and freedom and all. That's perfectly fine. There's no harm. um, but purely from a psychological perspective, and also I don't think law or psychology can be um, looked away from the context. So
Definitely.
purely from the context of the Indian society, where family-based system and children are mostly within family system, how do you see this debate of evolving capacities leading to decrease or allowing children and the best interest?
See, so when we talk about evolving capacities and best interest of child, we are not talking about just the ideology. We are actually talking about the developmental science. So the principle of evolving capacities, recognized in this international child rights law, it means that children do not suddenly become capable at the age of 18. Their abilities develop gradually. Even there are a lot of psychological researches that shows that the cognitive capacity, that includes your logical thinking, your understanding risks, your processing of the information, reaches the adult like level around 15, 16 years, by the time you're 15, 16. This is supported by a lot of large multinational researchers also across 11 countries, and a very longitudinal research was also done, which says and which stamps to this. But however, what I'm trying to say is the psychosocial maturity, जो हमारा impulse control है, जो हमारा emotion का regulation है, all of this continues developing beyond 18 years, often till the time you are in your early 20s. So, brain development research, all of this shows that the prefrontal cortex, which supports the self control, the decision making, still continues to grow. So, 16, 17-year-old may understand all of this, but so the gap between understanding and regulation is there, which we call it as a maturity gap. So, agar, if you're talking of the best interest from the psychological lens, I would say psychology tells us that best interest must always balance any kind of protection from exploitation, protection from any kind of forced early marriage, uh, the opportunity for education. So that is traditionally the best interest means protection from harm, right? The respect for so-called emerging autonomy. So it is not only about stopping the harm, it's also more about enabling an individual's growth.
Wonderful. Yeah. Uh, Himanshu, coming back to you. So, this
Yes.
the newer debate, that the age of consent should be decreased and girls should be allowed. While the courts are taking position looking at individual cases, the larger fear is that once girls get involved, there is a social backlash. There is a kind of backlash at the level of family, and also the possibility of the girl. Say there are a lot of elopement cases that are happening. So there are a lot of possibilities of negative impact on the girl herself. Uh, if she gets pregnant or there is some untoward incident happening, the cases of abandonment after marriage, early marriage. So there's a little impact. The fear is that the larger societal fear or the family fear is probably this is not the right age or appropriate age. And there's also linked to that generally, even in cases of, say, there are a lot of child marriages happening in India, we know, and most of those child marriages are basically say forced upon by the parents or the family. The consensual elopements are very, very minuscule compared to the larger number of child marriages which are arranged marriages.
Yes.
So there are two things which I looked at. One, the moment that age of consent is decreased, these families will be kind of empowered again to go ahead and marry their girls. So the legal kind of embargo on them will be taken away. So they will be again kind of free to marry them off. Second is that if the girls do it by themselves, the chances of again family not approving and then backing off or uh, uh, disconnecting relationships, the possibilities are there. State is, I'm not sure how prepared to take care of the kind of numbers we are seeing in UK and US of unwed mothers. So then it becomes not about one child; it also becomes an issue of for the other child also. So coming back to you, so how do you see this decrease in age of consent and kind of impacts it is going to have on children? And if you can also bring in the, say, context of Assam, it will be nice.
Yeah, Bikram, I would definitely like to bring the context of Assam. You have raised a very important point that, if we lower the age, then what can happen? Now, let me tell you what is happening right now because of the age. First of all, I am not going to comment on the legislative intent as regards to age of marriage and all, because there is already a demand for equaling the age of marriage for both boy and girl. So that's a different, thing. So first, let me tell you, take you to another, discussion. The another discussion is that, the uh, kind of cases which are, happening right now as regards to the age of consent debate or the, POXO, which is 18-year, are, sometimes it feels that suppose, say for example, one interesting case as regards to Calcutta High Court ruling, and when it came to the Supreme Court exercised its power under Article 142, extraordinary jurisdiction, and Apex Court declined to impose a sentence on a person who had sexual intercourse with a girl which is a 14 years of age, despite his conviction. Supreme Court said that the girl did not view the incident as a crime and had suffered more, from the legal process than the act of sexual intercourse itself. So that's one angle what I, uh, see it as. And then the other angle here is that POXO has a mandatory provision that's called for mandatory reporting. Now, because of this mandatory reporting in Assam, what is happening, you know, Bikram, and you must know about it, that there was a drive against child marriage in Assam, which happened in 2022 and 23, to 23 grossly. Now, the thing is, the pregnant women who are, underage are not even going to the medical facilities of the government, because then their age will become, then their husbands will be arrested, and then there will be a family, disabandonment, and then the entire family, I mean, best interest of the child who is going to born and best interest of the child who is going to give birth, both will be affected. So this is another, point here which we would like to, bring from Assam, like from this is from Assam's, point of view. And then, if we go through the cases, like if you go through the conviction in POXO cases, the first of all, the conviction rate is very low, and second one is that almost a, majority, I mean, not majority, but a sizable portion of the percentage of cases, like it may be ranging from 25 to 30% of cases are arising out of romantic relationship between boy and girl, where parents also, if they are against such kind of romantic relationship, can also, file a complaint and, go for legal, remedies, and that's why also, there can be misuse of the law. So therefore, I believe that it would be very wise enough if we incorporate a Romeo Juliet clause as it is there in the, European countries, and our high courts are very high courts are very effective in this regard. They have zealously guarded, the applied the Romeo Juliet clause to guard the interest of the child, and then also to protect their fundamental right to autonomy, dignity, privacy, and their right to choice. So that's all from my side. Yeah.
You are not audible, Vikram.
Not audible,
You're on mute.
Vikram. Why?
So I'm saying, very valid points you made with regard to Assam. The impact of the crackdown on a very positive side is very different. The numbers have
Yes.
decreased, and the health indicators have started improving. So a lot of the health
That's one
indicators,
point.
yeah.
Yeah.
So and there are certain things which takes a little time. So POXO is only almost like only a decade old. So when behavior and customary practices has to change, law will take a little more time to impact it on the field. The other fear is that while the cases under POXO and romantic issues are there, many of the cases where high courts are taking a stance, actually, if the Romeo Juliet provision would have been there, those cases wouldn't have fallen under that category. because the Romeo Juliet only allows for 2 to 3 years of exception. You
Yes,
have
3 years.
cases where the child is 16 and the man is 25 years.
Mm-hmm.
So even those high court cases won't fit within, even with that, within that provision of Romeo Juliet. So that only opens up another debate, which we'll surely have some other day. Astha, coming back to you for the last question. So you have been a JJB member. Now, Section 15 talks about three broad things. For a child, can a child be treated as an adult or not? So it talks about three broad things. One is the capacity issue, both mental and physical. The other is the understanding consequences, and fourth is the circumstances. To forget the circumstances part, I'm more on. So is it not a flip debate? While we all everyone who works on child rights issues and child protection, uh, in one voice we say Section 15 should not be there. Treat a child as a child, because that child does not have the mental capacity, or say understanding of the consequences, completely based on your the clinical and psychological aspect you are sharing. But when it comes to age of consent, we suddenly seems to believe that girls at the age of 16 are completely aware, they understand consequences, they can take decisions, and so should be allowed to go ahead. Why is this flip? Same yardstick, but a completely different standpoint.
See, if you ask me from a developmental comparison, the argument for lowering age of consent usually says adolescents 16 to 17 have evolving capacities. Criminalizing the consensual peer relationships somewhere seems to harm the young lives. And as I just mentioned, the close in age relationship should not attract harsh punishments. That's what the consent usually says. Now, psychologically, there is some basis here. Cognitive maturity reaches adult-like levels, again repeating, around 16. But emotional regulation हमारी 18 के beyond आती है. So consent capacity exists in part, but I will never deny that there is vulnerability that remains. Talking about Section 15 JJ Act, Section 15 allows a prelim assessment of 16, 18-year-old accused of any heinous crimes, just to determine the mental capacity, the physical capacity, the ability to maybe understand the consequences and the circumstances of the offense. But now there is a strong opposition to this routinely trying such adolescents as adults. Why? Because research ये दिखाती है adolescents ज़्यादा impulsive होते हैं. They are more influenced by their peers. Their brains are still developing, and they have higher capacity to reform and rehabilitate. So if you ask me developmental science, they support the reduced culpability but not the harsher punishment. And at first glance, if you see, it looks inconsistent. If a 17-year-old can consent to sex, why can't he be tried as an adult? But psychologically, these are two different capacities. Sexual consent involves personal autonomy, एक इमोशनल रिलेशनशिप, एक सोशल डेवलपमेंट. बट अगर हम जेजेबी की तरफ जाएं एंड क्रिमिनल लाइबिलिटी देखें, दैट इन्वॉल्व्स मोर ऑफ moral blameworthiness, the intent in the violent or the heinous conduct, the societal punishment, and the law treats them differently because their purposes differ. The consent law protects from exploitation, and the criminal law determines the culpability and the punishment. So I would say Yeah, go ahead.
No, no, no. I'm more on the vulnerability aspect of the child
Yeah.
in both the scenario, whatever, be it, moving towards violating some law, or the chances of moving away from the protective scenario of a parent or somebody. The moment you tend to be at the same level of an adult, and what decreasing age of consent actually means that your consent will have a value.
Right.
The statutory protection, or the protection in name of statutory rape, will be taken away. So you are as matured as another adult to engage and kind of move ahead and you know get into a contractual relationship with another person for certain activities. And because you are still not matured enough to understand the consequences, which in a very different context, as you said, we are fighting there, that this person moving ahead and violating certain law, which is conflict with law, as we say, uh, needs to be looked differently, because the mental maturity and understanding of the consequences is still lacking. And I just want to pick those aspects and you know uh, understand, uh, but when a girl moves ahead at the age of 16, with say, and says ki I consented, without having this, she also has the same level of maturity and same level of understanding what can happen post this, then we are kind of okay. No, no, I think she's matured enough to take that call, and so making her super vulnerable, and the predators are just waiting, eyeing for that situation to happen. So that's the only concern area. Your last thoughts, and then we can.
Me or Himanshu?
You ask them.
Okay. See, I think the lowering the age of consent uh, does not automatically somewhere mean that you are treating adolescents as fully mature adults. However, said that, uh, somewhere it does not also weaken the statutory presumption of vulnerability that currently protects the minors from exploitation. डेवलपमेंटल साइंस ये जरूर शो करता है दैट adolescents possess the evolving capacity, but also significant psychosocial immaturity, particularly in emotionally charged situations, I would say. सो देयरफॉर कोई भी रिफॉर्म आए वो ये एंश्योर जरूर करे दैट रिमूविंग द स्टैट्यूटरी प्रोटेक्शन does not expose adolescents to greater harm.
Himanshu, your last thoughts.
Bikram, I support the in lowering of the age, or I am actually basically I am in favor of the Romeo Juliet clause. But whatever Madam has just said, she also has substance in her argument that yes, adolescent is a very very tricky time, very where people can be easily motivated, you know for do any to do any kind of searching. So I in bracket I don't want to see that as relaxation, but I feel there should be some definite clause, definite exemption. That's what my point of view is. Otherwise, one final point I'm making, that nowadays these children are not only physically but mentally also they are very developed. They are not like us when we were of that age. And my daughter of my 7-year old, and when I was 7-year old, there is a difference, Vikram. I feel they're quite mature.
True, true. Then there's no comparison between generations. There's another research which says that this generation, for the first time, even in the evolving history, they are um, lesser in something from the previous generation. The first time in history, there's a dip, and a lot of researchers are coming on the new generation. So, thank you so much. I think the debate continues. Uh, we um, we still don't have a clear answer because this issue is so complex. The issue is so complex that it's not being anti-adolescent girls, but it's about the fears which we all carry, especially in the context of the Indian family and Indian culture, Indian society, where the the maturity of few within the larger society may be very high, but most of the children, and we are such a diverse country with such a diverse cultural and geographic backgrounds, where a lot of issues are not equitably distributed, be it um, access to education or access to internet and access to other means of information. Uh, a rule, a general rule, has to look at the majority of people. uh, Exceptions can be created, but uh, should the majority rule, which impacts the most of the children, especially historically also, as Himanshu started, the age of consent uh, act, which came in 1881 for the first time, it has always been looked linked with marriage, and so it's not something which the Indian society has still grown up to understand, that age of consent and marriage to be two separate dimensions of it, while it is. But so the debate will continue. I'm so glad we had both of you. Thank you so much, and we'll create more opportunities to have a chat with you. Thank you.
Thank
Yeah,
you. Thank you
thank
so
you.
much for having us.
Thank you.
Yes, thank you as well. Yeah, okay.